She is environmentalist by heart and have a passion to conserve the wildlife. Since past, she has trained around 8,000 forest staff and the forest officers in different states and contributed significantly to various states. She has received
But apart
several
from her
awards for the
profession,
same,
she is
even from the
environmentalist by
United
heart
States,
and have
for
a
her
passion to
contribution
conserve the
towards the
wildlife. Since
wildlife.
part, she has trained
She is
around
also a
8,000 for
guest
forest
faculty
staff
member
and the
of
forest
Wildlife
officers
Institute
in
of
different
India,
states.
Indira Gandhi National Forest Academy, Harvard University, Princeton University, and Clemson University. She is also acting as a bridge, means because as far we know, she is working with the Rajasthan Forest Department since 2005. She is acting as a bridge between the local and the government in in relation with the conserving the wildlife species. In today's lecture, she is going to highlight the journey of a wildlife laws in India. So I think that is a very important prospect, that we have a very expert who is knowing that since when the wildlife has been formed in India and what is the current scenario in India. So I welcome Anjana ma'am. Please, you are welcome to deliver a lecture in the conversation and the conservation.
Yeah, let me say something. She has been involved in a lot of activities. One of the activities, how best she can engage the people outside India also for the tiger conservation in India. So, to best of my knowledge, there is one Tiger for Tiger Coalition program that is she is running in collaboration with Clemson University. So she has been involved in all different domains, and the trust to which she belongs to now has been founded by Shri Kailash Sankalas ji, who was the founding member of the Project Tiger. So since then, you think about it, the story is continuing over the decades. So please continue, ma'am. We welcome you.
Good evening, everyone. Thanks, Puneet, for first of all getting an opportunity to see you and then get invited and be. And of course, I cannot see anybody, but I can see a lot of young researchers and I think students. It's an opportunity to address them. Though I feel little out of time, but I'll try my best to catch up with the latest situations. So, all of you again, welcome in the evening. I'm going to speak to you about something which, of course, sounds boring, but I'll try to make it interesting. Law is something which, is definitely a subject which is very special, and most of us always think law is something very dry. But I am one person who decided to bring in what do you call profession and have a travel from profession to passion. So I was inspired by none other than Kailash Sankla, who was the founder of Project Tiger and the Project Tiger director. After his just close to retirement, he founded this trust. He is known more as a Tiger man, but the legacy, of course, was created by him. I'm just following his uh, principles in conservation, and I tried my best to combine law and how to conserve, of course, the wildlife. The the topic for today, of course, is journey of wildlife laws in India. But basically, if you look at the past, we are not talking about the coded laws. Laws in India have been a process and an evolution by the rulers way back, I should say, from the time immemorial. But prior to that, the first thing which our framers of constitution did, if we can have the first slide, please, that is when India became independent and when constitution was written, the first aspect, as you know, duties and rights go hand in hand. And in our constitution, it is the fundamental duty. As you have a right to live in a clean environment, you have a right to have access to natural resources, but you have a fundamental duty constitutionally to protect it. If you can all see Article 48A, this is the foundation of our constitutional duty towards environment. It very clearly says that the state shall endeavor to protect and improve the environment and to safeguard the forests and the wildlife of the country. Now, this is a fundamental duty of the state. But can you leave everything to the state? No. Our constitutional framers were very, very wise. They said we have to make it twin system. One is the state who has to protect it, and fundamental duty of every citizen is also similarly divided by saying to protect and improve the natural environment, including forests, you have lakes, rivers, wildlife, and to have compassion, which we are all, I think, all Indians globally are born with that natural penchant for nature and the protection. And I'm not confining to Indians. I think all human beings somewhere along the line love the nature. I don't find any person who does not love it. But in Constitution, why I wanted to say so, that all of us are bounden with the duty not only to ask for the excellent environment, clean environment, unless you protect it, there cannot be any question of enjoying. Hence, rights and duties go hand in hand. So we are given this duty by the Constitution of India. This is the written guarantee given by the government to all of us, and we have to return this guarantee by implementing. So this was the written obligation under the Constitution of India. But we have a very interesting journey historically. And I want to begin from 3rd century BC, when Chandragupta Maurya, he was the first recorded emperor who appointed a head of forest department. It was created specially to see. I think there is some disturbance somewhere.
Yeah, please keep your mics off, please. All the audience I request, please keep your mic off. Ma'am, please continue.
Yeah, thanks. So Chandragupta Maurya was the first emperor who not only created a department, it is recorded, and also appointed a forest head with the purpose of not only protecting the wildlife, but also made certain rules for the game. What is it? Hunting, and hunting has been a very, very old passion among the royals and ordinary people for survival. But somewhere along the line, Chandragupta Maurya thought that we are using the animals for fighting wars, but at the same time, how much we need. So we have to go segregate it. So that is how, when this famous manuscript was written, Arthashastra. Arthashastra, in that this was recorded that how animals play a very, very important role in trade, in economics, but how would that come into effect unless there is protection for the wildlife? So this, in fact, became one of the very, very important administrative decisions in those times, to not only go about in the economics, but also to protect the environment. And each one of us is aware that when we have so many different aspects and so many different species, we have too many different castes and creeds around our country, each one of us down the line is in religion, various religions do have some kind of a protection and appreciation for the environment. And it would not be fair on my part unless I also mention the great contribution made by Jahangir. Now, Jahangir is very well known, for conservation and creation of gardens in the country, and also some of the finest gardens in Kashmir all around. But it was during his journey, when he used to go from one state to the other state, when he came across number of forests, he realized that so much beauty was around, and he decided that we must create beautiful spots for the public. And unless those spots were having some kind of natural animals, the existence of those animals, nothing could survive. So Sheshnag and so many other famous gardens of Jahangir, he first time mandated as a farman that you can only kill those animals who were turning into the man eaters. As you know, there was a huge number of tigers, leopards, cheetahs all around because there was not so much of man animal conflict. But at the same time, India was so rich in nature, but still to have a coded law for not hunting and not killing the animals was also going way back in 17th century when Jahangir first.
Please keep your mic off. I request you all. There is some background noise.
There is plenty. So basically, hunting of leopard was a very favorite pastime. Hunting of tigers was a very favorite pastime. But during 16th and 17th century, I stand corrected, it has to be 16th century, is the time when Jahangir almost started the system of having to protect the wildlife. So with this historical background, we move forward when the after the Mughals, the Britishers entered. Now, once, once we had the Britishers inside our country, the interesting part is this, that we have one code which all of you have been hearing about is Indian Penal Code. Now, Indian Penal Code was enacted in 1860. And I must tell you, this is the most well-written legal document, legal enactment, because there is hardly been any amendments. This is very, very important for everyone to know because it's so well written. It's so well written since more than 100 years that there has been no requirement for the legislators to either amend it or change it. So, but first time in the legislature of India, it was first time in IPC in section 428, which you can see on the screen. It was declared that killing, I like to make a difference, killing and hunting. There are two different aspects. So first time it was prohibited the word killing in 1860 when it was written, whoever commits mischief. Now, can you imagine? It is not written the word killing. It is written mischief by killing, poisoning, maiming, or rendering useless. Now, as you know, mostly it used to happen that in case there was any conflict by the animals in the personal, you can say, cultivation of any villager, then they would not kill the animal. They would either break the leg, or you can say make the animal unable to walk or disturb. So this was actually with the fine and as well as the imprisonment, which is up to 2 years or with fine. So this was first enactment in 1860. And then this not only looked after the wild animals, it also spoke about cattle, as you call in Hindi Maveshi. Now, this cattle is something which has been used for personal care and for personal use by the villagers. And this was also prohibited, but the word has been killing. It has not been hunting. So this was the first prohibition issued by the British government in 1860. Now, we are going as per the period. I want to say journey, that means the first was the informal, but it is not very clear historically whether in the times of Chandragupta Maurya or during the time of Jahangir, there were any punishments or any fines for violation of the law. But in the recent memory of more than 100 years, it's in only IPC which speaks about the penalties. That is in the form of fine or in the form of punishment or combination of the two. Now, after this, the Britishers realized that India is very, very rich in terms of forest, timber, and vegetation, plantations. So, first time they came up with this enactment called Indian Forest Act 1927. Puneet, I'm not very aware of the kind of courses these students are having researchers, but it is important that since now law has become a way of life, and it is equally important for the researchers to know that why these laws have been made. Because whenever you make any policy, whenever there is any reflection of mind of the ruling government towards environment, it speaks volumes about not only having it on paper, but it is always implemented through the legislature.
Agree.
So the government, the British imperial government, came out with this Indian Forest Act 1927, and I must again say so, remains unamended to a large extent because all the legislators, all the enactments, all the legal acts which were in operation by the Britishers are still, some of them continue to exist and operate and are a part of our legal system. First time in India, it was defined who is going to be the forest. And mind you, forest officer under this act is faceless, has no hierarchy, and has no protocols. Every person who is appointed in the forest department is to be called a forest officer. And it continues to remain the same till today. This definition of forest officer has not been changed. Accordingly, the purpose of this Indian Forest Act was to consolidate the laws relating to forests because I may tell you historically, every part of the country, that means every state was independent before India became independent because they were, of course, under the rule of imperial government. But once India became independent, it was the policy and planning of late Sardar Patel to say that in constitution we have to bring it under unitary form of government. Unitary form of government means you surrender all your forests, you surrender the entire freedom of your state. As you know, we had the system of rulers, we had all the royal families ruling respectively every state. So every state, which was according to the size and according to the geography location and its riches in terms of nature, forests, they decided to annex themselves with the government of India, that is called Union of India, and they surrendered their rights, they surrendered their forests, they surrendered their palaces, they surrendered their forts in favor of Union of India, and that was called Treaty of Annexation, means that everything belongs to Government of India. So in that process, all these forests which were under the Indian Forest Act, which was the law for consolidation, which for the first time defined what is a forest offense, which made it punishable, and acts which I have explained, felling of trees, kindling of fire in the forest, quarrying of stones. I'm not bothering all of you with the details of the provisions, but that was the basic object of this act. So after this, the Treaty of Annexation, which was signed between the states and the federal government, that's Union of India, that's how they became a part of Constitution of India on 26 January 1950. So all these rulers who were there, who the royal and the royalty, including their personal wealth, other than what they owned, was surrendered. So India became a rich country after all the forests and all the wildlife, whatever it is, came under the overview and under the constitutional guaranteed status of Government of India. So once it came under the Government of India, then all the animals, whether they are wild other than personally owned, were the government property. But unfortunately, from 1950 onwards, every state was having its own laws in relation to protection of reserved forest or whatever forests were declared. India never worked towards the legislature to take it as a you can say collective measure to see how to lay down the principles. So there was a big vacuum, and you can say hunting of these wild animals continued relentlessly. And way back in when it was beginning of the century, we had more than 40 to 50,000 tigers. But gradually, because of though the royalty annexed itself with the Constitution of India, but there was no prohibition of hunting. So there was no prohibition other than these two sections which I told you in the year 1860. So you can imagine that for whatever situation was, country was facing absolute decline, and this became worse towards the 60s. And that is the time when our then Prime Minister, Mrs. Indira Gandhi, decided to take situation under control. And for the first time, Ministry of Environment was dedicated. And that's where our founder, who was at that time a forest officer in Rajasthan government, was asked to take a long journey across the country to first see the habitat of the wildlife. Late Kilar Sankla traveled across the country and decided to see what is the natural habitat of tiger, what is the natural habitat of the critical animals. And that is how the Project Tiger was born. Now, Project Tiger and Wildlife Protection Act, they went together. Why? Because this project took place after I could say, a long search of 6 to 7 years, or maybe more than that. That is when the first report was handed over to the then Prime Minister, and she decided to have Project Tiger. But it was deliberated that what is the
दीदी
use
आप
of
कैसे लिख
Project
रही हो
Tiger in case you don't have any legislation to protect the wildlife. So that is where this very, very important in Act, Wildlife Protection Act 1972 came into operation. This is the act which is the backbone of the wild laws in this country, because I'm very, very proud to say after the Wildlife Protection Act 1972 came into operation, 6 other countries followed it. Bangladesh, Nepal, Bhutan, Malaysia, all of them have, if not similar, but most important provisions. And they have also included in their acts for the word hunting. So in India, for the first time, hunting was prohibited. That means prior to 1972, there were no penal consequences for hunting any animal. So you can imagine from 1947 until 1972, there was no law to prohibit hunting of an animal. So hunting was made an offense, and prohibition is defined under Section 9. And modes and ways of killing were also defined. First, we were protecting these wild animals by making a schedule. There are almost 4 active schedules which has classified and codified the animals. According to the schedule, if any hunting is carried out for any one of them, it results into hunting. And because of being a prohibited act, under this act, the consequences follow. As per the latest amendment, if you kill any animal in Schedule 1, tiger happens to be there, and other cat group is there, minimum punishment is up to 7 years, not more than 7 years. It is up to 7 years. Minimum is 3, which was earlier 3. Now it has been increased to 7 years. And it is a case which is a private complaint case to be filed by the Forest Department. I don't want to go into details when I come to the maybe discussing one or two interesting cases. I'll take you through that. So we became the first country in Asia and in the world, one of the few countries which has prohibited hunting. Because in many developed countries like the United States of America, other than hunting of their national animal, which is grizzly bear, there is no punishment for hunting any other animal. And same as many other places. So we took the lead, and that's how twin system came up. One was the birth of Project Tiger and the Wildlife Protection Act. Now, with the passage of time, we had lots of confusion and conflicts between center and state. Now, center and state, I like to tell you that when India is a system which is working under the unitary system, and federal system are two different systems, where there are under the constitution these subjects which are divided. Some of them are state subjects, some of them are central subjects, some of them are concurrent subjects. Environment and policies of forest, etc., are under the central domain, but states also have the power under their respective acts to declare forest which are reserved and protected. But if there are national parks, they can only be declared under the Wildlife Protection Act. That means under the power of the central government. Now, once this became an issue, that means after the Wildlife Protection Act, several states started, because of the development, as you know, economic growth also became essential. So they found that several states found that forests were not coming handy and they were becoming an obstruction. So they decided to make the use of forest area into non-forest area. So looking at these situations, it became absolutely important for the government to consider how do we protect and how do we divide these policies and the conflicts of center and state. So that's how we came up with this Forest Conservation Act 1980, exactly 8 years after the Wildlife Protection Act. Now, what is the use of this Forest Conservation Act is that any reserved forest, that means any forest which has been declared by the central government, and the state also has a part of it, obviously it will be within the territory of the state, and the state wishes to have the reserved forest area to be used for the non-forest, it cannot do so unless it seeks the permission of the central government. Now, once that is to be done, we have several examples, like we have in Gujarat. We had this issue in Northeast, where the permission was essential to seek the consent of the forest for the central government. Mostly it was regarding the mining, use of certain areas where they could seek permission for mining. And the same situation came up, as all of you know, Tarun Bharat's case in Sariska. Despite the central intervention and prohibition, there was a lot of mining going on. I'm sure when we have the time for question and answers, I'll just take 5 to 7 minutes to explain those interesting episodes. But Forest Conservation Act 1980 is a reflection on streamlining the relationship between center and the states. Now, from this particular period, there was one growing dissent, or you can say concern, among the governments was with regard to the status of the tribals. as you know, tribals have been the part of forest for a very, very long time. And when wildlife protection came, there was a interesting process. I may seek the consent of the speakers if I may share that. Process is important for all of you to know that whenever any national park is declared, there is a full-fledged process of identifying the forest, which must contain flora, fauna, natural resources, and of course, confirmed existence of the wildlife animals. After this intention of the government is there, they demarcate the area, and mostly they had villagers inside. Now, once you had villages inside, obviously you'll have villagers as well. So you were actually way back, these national parks have been declared since 1960, 61 onwards. So it became a big conflict that you were trying to uproot these tribals from that area where the dependency has been for a very, very long time. So then the process is that you give your intention to declare this particular part a national park. And then you seek objections from those villagers who are a part of that forest. And because they are the landowners, then they are given an opportunity to file their objections, which are then decided in a time-bound manner by the collector, and they are given alternative land, they are given compensations, and that is how that area is then protected. And with various amendments under the Wildlife Protection Act, that act has been upgraded, compensation amount has now been enhanced. For earlier it was very low, now we can go up to 10 to 15 lakhs where they are given alternative land, and that is how the national parks were declared. Now, national parks were declared in the Wildlife Protection Act, and as I said, the states also have the right to declare forest and protected areas. But then there was a lot of unrest among these tribals, and they said, we must protect our rights and we should be given a recognition and a place to continue to live in these forests. First time, since I'm an activist to the extent of protecting forests, I found that when this Forest Rights Act 2006 was being considered in the stage of bill, there was a big, big amendment which brought in a big conflict with the government, state government as well, that we give them recognition. And under the act, earlier the date when it had to come to effect was way back in 1980. That means, but when that was the stage of the bill, but when the act came, it became operative from 13th December 2005. That means any person having the right in the forest was entitled to get 4 hectares of land under this act. And as per this act, that land can be used for very many purposes, which is fairly inconsistent, not consistent. It is inconsistent with the mandate of Wildlife Protection Act. It is inconsistent with the mandate of Forest Conservation Act and some of the enactments of the Indian Forest Act. Be as it may, I don't want to enter that arena, maybe some other time, but all I want to say that when there are legislatures, we always try to, it should be consistent with each other, with the objects and reasons. But with this Forest Rights Act 2006, attempt has been made to protect the traditional forest dwellers, the scheduled tribes, and the recognized right holders under these forests who have been there since time immemorial. Now, this also establishes the responsibilities with the authorities for sustainable use, conservation of biodiversity, and maintenance of ecological balance. I wonder how you create it, but this cannot be done unless there is a harmonious construction and harmonious interpretation of these legislatures, and resulting in a very balanced policies. Now, policies are being interrupted, policies are being tweaked, policies are being compromised for the development. Now, both are important. We are not into that debate. But the journey of wildlife laws, at least on one ground, has been consistent. That is, it has been pro-protection. So basically, whatever we have looked at, whatever has been my little experience around the wildlife laws, because why I say little, I think even lifetime is less to understand, because law is evolution. It keeps changing. But only one thing doesn't change is your passion for conservation, which I'm sure all of you are looking into. So I would rather go interactive. This was the presentation to just give you I can say an overview of the existing laws, because the detailing, of course, is something else. But certainly, I would stick to the time. And Puneet, if you wish, we can throw the floor open for question answers, and any other detailing if you want, I'll be happy to answer. Muted.
Yeah. Okay.
Yeah, thanks.
So I thank you for your fabulous presentation. You tried to compile everything within 30 minutes of time, starting from Chandragupta Maurya to the Forest Rights Acts of 2006. It was really a nice compilation. I just want to ask I have one query in my mind. When you look into the concept of forest management in Arthashastra, that Chandragupta's time, also when you see into the scripts available of the Ashoka's time also, there was less interference in the business of a common citizen and more governance. Then we go into the time of a Mughals, though hunting was more, but there was also kind of a little bit increase in the interference. It became further increased interference with the British government. And when we started all these acts of, say, from Indian Forest Act to Wildlife Protection Act to Wildlife Conservation Act, it increased a lot. And when we look into the overall biodiversity loss, you see it increased. So when we talk about the biodiversity loss, we always try to mention that from the Mughal period, India started experiencing the decline in the biodiversity. So my query is, with the enactment of Forest Right Regulation Act or Forest Right Act 2006, which provides all equal opportunity for the local or the tribal communities also to express their stake in the forest and its resources. What do you expect? Will it lead to decline in the biodiversity, or it will create a kind of an harmonious relationship with the people, and we'll see a future increase in our biodiversity richness in next few decades?
I think the answer is very clear, because once this Forest Rights Act, as I said, there is always a balance of rights and duties. But no, according to me, whatever I have seen closely, there has been a decline, because it is not due to the scheduled tribes or the forest dwellers, because they have been there since long. It is the greed, it is the interference, and it is the constant pressure on these areas where they are supposed to live peacefully, the animals, and they have been coexisting with human beings. But because the greed is going up, we are planning, the governments have been wanting to develop. So all this has been very costly affair, and it has taken a toll on not only biodiversity, but even with our existing resources. And the examples are when you see so many conflicts around among man-animal conflicts. Now, whatever research we have done in terms of poaching, all those cases which I say I am in the enforcement, I'm more so into the enforcement area. And I find this is all due to the conflict. Because once the development is there, you can see there is a lot of disturbance. Animals run out of their care of their critical habitat, and then they're disturbing, because you see, it is something like somebody entering your house and disturbing you. So the entire non-harmonious construction between the legislature has created a lot more confusion. It is less protective but more destructive. So in the coming time, I'm alarmed, and I can also say that unless there is a balance created now, we are heading towards worse times.
Yeah, actually, I raised this question because maybe you are also interacting with a lot of forest officers and managers. We also had an interaction, and every time when we interact with the forest managers, they always says this Wildlife Forest Regulation Act is actually making them crippled when we talk about the management of the forest. It is creating a lot of issues. So, what kind of the amendment you may suggest in this Forest Right Act? Or what you think,
You
which clause?
see, the problem in the Forest Rights Act is this, Puneet, that there is no involvement of the.
Your voice is not audible.
Can you hear me?
Yeah, now I can hear you.
Saying that the involvement of Forest Department, powers of the forest officer, which is given very clearly in Section 50 of the Wildlife Protection Act, it is given in the Indian Forest Act. There is no role, there is no involvement of the Forest Department in this. So basically, unless there is checks and there are checks and balances, you cannot bring both the things together. But at the same time, we have to remember that these forest dwellers and these scheduled tribes who are already existing there, they also cannot be ignored. So what amendments would be that use of this land has to be restricted. Right now, there can be a number of areas and they also have a right to sell. What is happening? The land has been given to these forest dwellers, but they are not keeping it themselves. They are selling it. So once they are selling it, more and more commercial activities are entering into these sensitive areas. You can say high voltage cables, and you can say a lot of other units, your other kind of activities are taking place, which are not very complementary for the existence of forest. Now, tourism, it's a very much debated subject. But when you come to planning, there is no planning. The problem is in these areas, there has to be consistent planning. But there is only going to be limited numbers of resorts or limited number of exploitation of the area. There is none. There is no policy. So what is happening? It's all haphazard, and you can see number of rules are different. In certain states, if something is allowed, the same thing is prohibited in the other one. Certain states are under a lot of pressure. Some states are having no visitors. So this is a lot of problem, and these people, the dwellers, are enjoying a lot more commercial viability of their land on in those states where the government, the ruling state government, is wanting more and more development. So this is also another confusion.
I would like to bring in attention about the kind of the model that the Himachal Pradesh government is doing right now about engaging the local community in eco development. That is one thing that the government should think about while engaging the people and ensuring the livelihood of the local communities. That may reduce some burden on our forest resource and may lead to a better biodiversity management.
Yes, you cannot survive for conservation efforts unless you involve the local communities. But how effectively you are involving them,
Exactly.
that is to be seen. That is to be seen. I have seen eco development committees where there are no members. Even if the members are there, they are not coming in the meetings. I have been a member for Ranthambore National Park for the last, I've forgotten the years. Whenever we called for eco development committee meetings, there were hardly any takers. And it seems on the report, it used to say, we have taken 5 years to give them, a solar light, solar panel, whatever it is. Though there is money being given to them, there is a huge amount of funds now under Tiger Foundation reserves and funds, but it is never utilized. So unless you involve local communities with certain meaningful projects, they will never be able to get these benefits.
Okay. Okay, I understand. Another query from my side is like we have a very strict penalties for poaching cases and the person those who are involved in the illegal wildlife trade and other activities. Still, you find an exponential increase in the wildlife trade over past few decades. As we have seen in other kind of the crimes also, the penalties are not one that can basically demotivate the people to engage in the crime. So, being as a lawyer, you have been involved in a lot of poaching cases, resolving those cases, and in the law, also in the court. May I know your suggestion about this kind of a penalties? Because in some states, the penalty has been increased to such a high amount, like in case of a Kaziranga National Park for hunting a tiger. But still, you find a poaching going on. So, what kind of the suggestions you may have when in terms of should we remove the monetary penalty to the some kind of a social service, time bound social service in case of all these kind of a wildlife offense?
See, the only state of Assam has the penalty of life imprisonment for killing the Schedule 1 animal. It's the only state. In remaining states, it is up to 7 years. The difficulty in penalty for poaching for these animals, I'm talking of Schedule 1 or any other, is this the time period. The minimum period, the minimum time taken for a trial for a poaching case before the chief judicial magistrate takes anything between 7 to 8 years. After that, you have an appeal which goes to the sessions court, because up to 7 years it is sessions, and then thereafter, after the sessions, you go to the appeal in high court, and then you go to Supreme Court. The famous case of Sansar Chand. I want to mention here that Sansar Chand was basically a trader, but everybody thought he's into poaching. No, he was trading, illegal trading of the animals. Now, by the time Sansar Chand was put behind the bars, he died of diabetes
Yep.
because of other complications. He was behind the bars, but what by the time we got through him, I think by the time he was arrested, he was tried. Most of the offenses were already complete and already harm was done to the wildlife. Same is the case of other famous poachers. So by the time the case is registered and is brought to trial, that period is so long, most of the witnesses are either transferred or they do not appear. So basically, my suggestion would be it should be made into fast track courts. It should be tried very fast, and there should be a special court for only wildlife offenses. Right now, all the magistrates are trying as a part of the regular offenses. So it takes as many years as it takes for a bouncing of a check case. There is no importance given to these cases. I have been doing it myself. I used to travel all the way to Umaria near Bandhavgarh National Park, where this famous case of Sita took place. Sita tigress was the one which gave birth to maximum number of cubs in those days, and it was in the year 2004 when Tiger Trust intervened, and I used to personally go and prosecute. I remember, despite full-time efforts, we finished and we won the case and we got those poachers convicted. It took 3 years. It was every month, it was funds of Tiger Trust, it was help of the forest department. So you can imagine how many efforts we made to get on to be there. But can it happen in every case? No. Right now, the percentage of conviction of these poaching cases is dismal level of less than 2%. First of all, if 50 tigers are lost like this year itself, more than 50 are there. Out of that, about 20 or 25 poaching cases are there. But when you ask the department, have you registered the FIR? The answer is half of them are not even reached beyond investigation. So basically,
Your video is not coming, ma'am. There is some issue in your audio.
yeah. Can you hear?
Yeah, now we can hear.
Yeah. What I was saying, that the system itself is so slow that it takes many, many years for the conviction proceedings to take place. So we need amendment in terms of disposal of cases. It has to be time bound. and it has to be on fast track mode.
See, ma'am, when we talk about the wildlife trade and poaching, the persons those who are involved in actual killing of an animal are not the persons those who are getting a lot of monetary gains, like the traders. So we need to have some kind of a mechanism also, what I personally believe, like we have a mechanism of compounding of the offenses. So we should have some kind of a mechanism, so that we can have a kind of an adjustment where these kind of a cases can be addressed in a better way. That I personally feel.
You are right, but compounding can only take place where there are no penal consequences. Wherever there are
Yeah,
penal
agree.
consequences, that cannot be compounded. So under the
We agree.
Rajasthan Forest Act, for instance, or the state acts, those kind of smaller acts of, say, felling of tree, which is outside the forest area, all those things can be compounded with the adequate compensation. Maybe any of the participants, they would like to ask any questions?
Ashutosh, you have a questions? Maybe you can continue.
Yeah, probably I means already I have got a question, but it has been already well answered by the ma'am. And as there was a one question from the audience also, and it was the what is the potential of Forest Right Act in 2006. So I think you have the first question you asked. It is giving the answer. I think Gainka must be satisfied with the question. Ma'am, I have one question that maybe you means you are already involved in so many years in a law profession. You must have seen the wildlife crime cases, and there are a lot of the cases when these poachers get freed because of the evidences. We have the representations from the forest department. What you would like to suggest that how they should, because most of the time, as you said, they are not having the proper file work, so that they can present in front of the honorable court. So means what you will suggest to them, that how they can proceed and what are the major proportions they should cover, so that the court should convict them, means they can give the proper sentence to the poachers and the hunters.
See, the basic problem is this, that whoever detects the crime is the forest guard essentially.
Yes.
And the power is given to investigators to the range officer. So the biggest challenge which I found after training 8,000, it's not a small number, across the country, whether it was Rajasthan, whether it was Madhya Pradesh. Puneet has been with me in several of these enforcement trainings in Goa, everywhere I have done it. I found the most powerful person is a forest officer under the act, but he does not know how to use it. That's the tragedy. If he has the power to arrest, he has the power to go enter the house without warrants, he has the power to search, which is much higher than the police officer, but they don't know how to use it. So the problem is that by the time they lodge the complaint in the court, their investigation is inadequate. And what they have to do, I'll just give you an example. If in case you detect a crime, at the time when you detect the crime, the police is very swift. They continuously keep on doing investigation and they, register the case immediately. But the forest department is way behind. By the time they do the investigation, they go and they establish communication with the suspect. As we cannot call them accused till they are proved. But at the same time, forest officers' investigation will run into several weeks and months, and sometimes they don't even find the accused. So, similarly, despite all the efforts by the department, their investigation is very poor. And that results, once your investigation is poor, your foundation for registration of a case is poor, so you cannot do a very effective trial. So, these are the major issues which we try to fill in and try to tell them that how you have to use the power. It is sometimes so frustrating, Ashutosh, that it is somebody you have to tell a person that please hammer, do something, unless you have the power. Here you have all the power and still you are not able to arrest the person. हम कैसे जाएं जी, बड़ा मुश्किल है, ये तो हमें समझ नहीं आ रही है. So half of them are talking about infrastructure, half of them are talking about how to implement. So those are the gaps which we as trainers cannot fulfill. It is the administrative exigencies which they have to do. But there is a lot more improvement now. Over the period I have seen in the last 7 or 8 years, that things have improved, but much is desirable. So my suggestion to them would be that they must continuously learn, and they must update and upgrade their skills for investigation, and book the crime in the most effective manner.
Yes, ma'am, exactly. I also realized the same thing. And because we conduct a capacity building workshop for the forest department as well as the border security forces too, they are most of the time they are not aware what are the parts are illegal, what are the legal things that the person can take. And even some people, just like there are some myths that they have to wear the tiger claw, and they have to wear the tusk of some means the tusk, the bangles made from the elephant tusk. So they are not exactly aware about the things. So as per uh, the requirement, as you said, it is very, and you have trained around 8,000 forest guard, which is not a very less number. So what was your experience that whether they have significantly gained a knowledge over the years, or means the situation is remain constant, that earlier the situation was the same and is still the same? The forest
No, there
department.
is a lot of improvement because of the senior officers getting involved. I should say, I can see significant improvement in the last 5 6 years. It took me. I started this since 2003. In 17 years, I could say first 10 years were fairly. You can say it was just trying to take a position where they started picking up. But last 5 6 years, I can see lot of improvement now. Lot of improvement, and if I'm training say about 50 participants, at least 35 interact. So from 5 to 35, it has taken me that much time. But now senior officers are really involved, and they are also doing a lot of work on their own for training plans. Yes.
Okay. So we have a question from Chanchal Tyagi, and she's asking, is there any criticism of Forest Right Act 2006? I think you have already answered this question, that
There
there
are a
are
lot
the,
of criticisms
Say,
about it.
I won't say it is total criticism,
yeah.
because you see, the point is they were the ones who are the biggest sufferers. They had no, it is somebody, who has been there for hundreds of years. They had been maintaining the forest. We must admit that. And it is only when you see, when you enforce something, when you regulate something, there's bound to be a conflict. So this is what has happened actually. So they felt threatened. Their first reaction was that, now comes the act, now comes the measurements. They are trying to throw us out. They are trying to alienate. That sense of alienation was setting in gradually. So with this act, this was a step forward to give them that you mean something to us. We are recognizing your rights, and that is why there was a lot of support for them. That Ministry of Tribal was the pioneer ministry to come forward for their protection. Why I'm criticizing is this, that they are not to be blamed. It's the policy makers who have to create a balance for both, giving them and recognition, but a balanced protection also. Where they failed was that, but I must tell you, the gainers are not them. The gainers are somebody else. That is where I am critical about it. I have no criticism for these dwellers or the tribals. I mean to say, given a choice, they still like to do something traditional. I'm only I'm against those people who have got in between and tried to take away something which they were nurturing, and I could say extra development in these areas by the policymakers. So I am only saying, eventually, this act, which was created for something different, has resulted in totally different situation. So
Yes.
we really need to look at like that. So I'm not anti Forest Rights Act. I'm only saying that whether you have got the due, the purpose. That's the point.
Yes, ma'am. Exactly. You made a very right points, and we are very thankful to you that you have enlightened us with the forest laws, with their means what are the pros and cons even too, and even the way of development in the forest policies. So. With the few last words, we will means on the behalf of our team and Protect India Foundation, would like to thank you so much for giving your precious time to us, ma'am. Thank you so much. So,
Thank you very much. It was certainly another opportunity to come to the forum and explain. I only hope I was able to, you know, given whatever time was granted to me, to enlighten, I mean, say to share my views. And I must say these views are only out of my long experience with them. And I like to be open about it. But if I have in this process said something which has hurt anybody, I'm sorry. But I'm sure all of us are lovers for conservation and we are all working towards it. And wish you all the best to each one of you to pursue your passion. And passion is something which will take you a long way, and I hope, and I will be again very happy to share this platform anywhere, anytime, and help out all you young people in any way I can. Thanks again from the Tiger Trust as well for inviting us and making us a part of this wonderful evening. Thank you very much.
Thank you, ma'am.
thank you.
Today.
Thank you so much, ma'am.
Thank you.
I just wish to inform the
Thank you, ma'am.
participants that tomorrow we have another lecture from Dr. Hemant Joshi, but there is a slight change in the time that tomorrow we will start at 5 p.m. as the busy schedule of Dr. Hemant Joshi. He's from Center for Studies on Wildlife Management and Health, Bikaner, and he will present his lecture on rescue procedure rules should be recalled prior to any capture operations. So we request all the participants to kindly be present at 5 p.m. and we will provide an e-certificate to all the participants after the completion of the this conservation conversation meet.
Thank you, sir.
Thank you, sir.
Thank you, sir.